Thank you for joining us for this webinar for Done with Divorce. We are going to be focusing on one of the most important kind of pieces when you're coming out of a divorce, something that everyone should be making sure that they have taken care of, and that is their estate planning. So we're going to be talking about estate planning considerations with one of our guest speakers. This is Adam Abramowitz. He is an estate attorney. He's with the law firm Stein Sperling up in Maryland, and he is licensed in Maryland, Virginia, and Washington, D.C. So I'm going to turn it over to you, Adam. Thank you for joining us.
Thank you for having me. It's always a pleasure to come and present. So as mentioned, I'm with a law firm up in Rockville, Maryland called Stein Sperling. We have offices also in Virginia. And so the presentation will kind of focus, generally speaking, on the topic of estate planning, but I think you could apply it generally to Maryland or Virginia, or even the District of Columbia for that matter, depending on where you are as you're viewing this, but always as kind of a, warning, make sure that you consult a local attorney depending on, where the issue is, because the local rules are going to be a little bit different. With that said, we can proceed. So here's kind of where we're going over the next, I'd say 45 minutes to an hour in terms of the estate planning considerations. And so the premise of this is certainly that you are going through or have gone through a recent divorce. And so we're going to look at kind of putting the pieces back together. Where do we go now? Some current developments that exist that have shaped how we look at estate planning now and into the future, some of the things recently that have occurred. And then we'll dive into more of the kind of substance, which is the initial action items, what you should be doing. And again, you'll hear a lot about a checklist and following through on agenda items and things of that nature. And then we'll turn to kind of, as we've gathered up all the information, looking back at the basics. What is an estate plan? What are we actually looking at? What is the scope of it? What do we need to do? And then we'll kind of go into kind of moving forward, what you need to identify, what you're going to be looking for, what happens if you do or don't do the various things that we're talking about, and then how to maintain it as you go along. So we start with putting the pieces back together. And it's more of the who, what, where, when, how type of analysis. And so as we kind of have gone through or are going through this legal process or the settlement of some sort of separation or divorce, the good news about some of that is, number one, fresh start, right? We look at this from a fresh perspective. I'm a big believer in let's not look backwards, let's look forwards. And in doing that, and again, one of the positives that comes out of this is you've been able to kind of do an inventory, and you should have a fresh perspective of what do you have? What are your assets? What are your liabilities? What does a budget look like? All of these various things as you've gone through the process to put together some sort of settlement or agreement going forward. And so that should help you as you put the pieces together for an estate plan. And then you're going to look at where is the plan going to be rooted? Ultimately, it's rooted where you are. And so is that a situation where you've gone through a divorce in Virginia and you're going to stay in Virginia? Is it a situation where you've gone through a divorce in Virginia and you're going to move to the District of Columbia? You want to be aware of that. Maybe it's a situation where you're going to stay in Virginia for maybe a year and then you're going to move. All relevant things to make your attorney or whoever you're working with aware of, because you're going to want the plan to move with you. Where are you? And that's not just physically, that's mentally as well. We're looking at kind of what headspace are you in? A lot of times, while these things are fresh in your mind, is the best time to address them. Many of us, I'm sure, that are watching this have gone through a situation, especially when it comes to estate planning, where you go in for your quarterly meeting with your advisor or your annual meeting with your accountant, and they say, do you have an estate plan, or when's the last time you updated it? And it's fresh in your mind. Okay, I'm going to talk about my estate plan. We're going to look at these various things. And here's where we're going to go. And then you leave that office and you set it aside, and 6 months goes by, a year goes by, and it just never came up again. And so when we talk about where am I, we're talking about also the headspace. Where are we thinking? What are we able to deal with? And while these topics are fresh in your mind, is the best time to deal with them, because it's the best time to see it through to completion. Keeping in mind, as we go into the next couple of items, the control piece. Biggest thing is to look in the mirror and realize you're the boss. You're the boss of yourself. You're the boss of this process. You're the boss of your plan going forward. Every little piece of it, each word of it, how things are defined, where things go, who's helping you make decisions, that is all you. You're going to be in control of that. It's not for us as planners to tell you what to do. It's our job to tell you how to get from point A to point B to accomplish the goals that you set out to accomplish. And so even on a daily basis, it's good to look in the mirror and realize that the person that's staring back at you is the one that's in control. And that's how we always want to empower our clients. And that's how we want you to empower yourself as you go through this process. It's not doom and gloom. Look at it from a positive spin. And how do you proceed? You proceed with structure, you proceed with a plan, and you proceed with organization and follow through. And hopefully some of this will give you the roadmap on how to do that. So a couple of things to just keep in the back of your mind is some current developments of what's impacting how we do planning. Certainly still, we're feeling the effects of the pandemic as we continue to separate from the core time frame that the pandemic was upon us. And what has that caused? In certain jurisdictions, it's caused a different view on how we do estate planning. We've seen delays, whether it's delays with courts. When somebody has died during the pandemic, sometimes it could take 6 months to get an estate opened because nobody was in the courthouse, or nobody was processing files, or people weren't coming in every other week to get documents that were filed. So it's something to think about when you go into a meeting, that in some respects you need the court when you're administering an estate if you only have a will-based plan, and we'll talk about that. But by using things like trusts, we can avoid having to use the court as much to depend on the appointment of somebody to administer an estate, and we can have somebody that has more immediate control. And so things have skewed towards that type of mindset, at least, and having those conversations where sometimes it wasn't ripe to have, depending on the individual who was doing the planning. Access, along with delays, and the reason we talk about delays is who was in the office, and many of us have gone to more of a hybrid workplace that our companies or where we work is a part of. So access to administration, access to information has caused, again, how we view things in terms of planning. And so keep in the back of your mind as you're doing this, the plan that I'm setting out, how's it going to be implemented, and how will that be affected in this new world that we live in? Some of the legal updates, during the pandemic, and we still get asked a lot of these questions. Do I need to come into the office? Do I have to sign things? Certain jurisdictions implemented remote execution procedures where we could sit on a medium like this on Zoom and sign things with a notary and with witnesses. Depending on where you are, a lot of jurisdictions have gotten rid of that. Those were more emergency protocols, but there are some states that are starting to implement things more permanently from a remote standpoint. I know certain courts where I am here in Maryland have gone to scheduling conferences, for example. A lot of them are more permanently by Zoom. The District of Columbia is still having trials and hearings by Zoom. And so it's going to be hit or miss depending on the jurisdiction, but you might want to just consider that. But I would tell you to err on the side of thinking that at some point when you're going through this, you're going to need to go in person to execute documents. And that's for a variety of reasons, to combat fraud and things of that nature. Tax considerations. There are a lot of updates, not necessarily pandemic related, But things that were happening, those who had small businesses were dealing with PPP loans. But consider from a tax standpoint, things are shifting as we start to make our way towards 2025, 2026 as it relates to estate taxes and gift taxes and different things in those buckets. So make sure that when you're having these conversations, consider those as you go forward. Um, Litigation continues to be on the rise. That has been in my presentations for the last few years. We're still uncovering things from the pandemic that are causing litigation to occur and litigation to occur at a high rate. You will see that courts are still kind of backlogged with issues that arose during the pandemic. And so it is causing a lot of hearings and trials back to back to back to back. And so you will kind of see the statistics that litigation is on the rise, both from a standpoint of issues are getting more complex, but you're also seeing that family dynamics have changed a lot over the last handful of years, and attitudes and things of that nature have changed significantly, where it is just promoted an environment that is very litigious. And so when you're doing your documents, make sure that all the considerations are met. If you have concerns over family dynamics, address those in the plan up front. This is the time, again, you're in control. This is the time where you can address all of those issues now while you're competent, versus when issues start to occur in the future, 10 years, 20 years, 30 years down the road. You can address these things out front. And so now's the time to do so, to prevent, hopefully, any of these types of issues that we're seeing from occurring. And then, we're still kind of dealing with issues where people still feel isolated. Not everybody is as connected as they used to be. But pros and cons. A lot of the remote stuff has been helpful. It gives added access to things. You can have multiple meetings in the span of a day and not even leave the comfort of your office. And so there are good and bad things that come from this. All right, so now let's dive into the substance a little bit. And so we've kind of talked about where we're going. We've talked about some considerations initially to think about as you start to contemplate the process of, what am I doing here in terms of an estate plan? Where do I need to go from a divorce process, a separation process, to getting a new plan in place? And so, I said I'm going to mention a lot a checklist or organizational tools or an agenda. This is where that really comes in. These initial action items. What do I need to do? The first thing is, who are you connected to? Who is your advisor? Do you have an attorney? Do you have doctors? Do you share doctors with each other? Do you have an accountant? Make a list of all those professionals that are in your life right now. And then go through the analysis. Okay, I have this advisor, or I have this lawyer, and I can speak, from that perspective. Is there a conflict going forward? We share the same lawyer. We're coming out of a divorce. Does one of us have to leave that lawyer? Do both of us have to leave that lawyer? There are certain ethical considerations as a lawyer that we have to advise a client of, and so you should consider those as well. And that's just one aspect of this. Those can apply to financial advisor, accountant, your doctors. Some of it is ethical considerations. Other things are purely, personal feelings. Do I really want to go to the same bank? If I have a checking account at XYZ bank and I may or may not run into my ex-spouse there, do I really want to be doing banking there? Do I still want to deal with the same banker who may or may not keep confidences as we're doing banking? So think of those things as you're making this initial list of, who am I connected to? And jot down next to it, I'm not I'm not concerned about a change I should think about, or a change is necessary. And if you're in that last column, then make a list of where the changes are necessary, and rely on your team, rely on your friends to give you some suggestions of who you could change to. Review other things in your life, not just those individuals you're connected to, but social media, and your email accounts. Did you have a joint email account, for example, for your house where all the utility bills went to it, things of that nature? Does that need to be shut down? Does your ex-partner or spouse have access to your email address? Do you need to change the password? Do they have access to your phone bill, and can they see your text messages? Privacy considerations, all of those. Again, list them all down as considerations. And then once you kind of scope out all of those immediate concerns, at the end of that list, you should grab your estate planning documents. Do you keep them electronically? Do you keep them in hard copy? Do you have a binder? Where are they? Is it something that you need to go to the attorney to get a copy of? But establish, a set, if you have them, of your documents and read through them. What do you have? Refresh your memory. Maybe you haven't done them in 10 years. Maybe you did them, but you don't recall what you did. Maybe you weren't necessarily the person in your relationship that was in control or in kind of the primary contact for all of this. And maybe you didn't pay as much attention as you should have. So now's the time to familiarize yourself. As you're reading through, maybe you have minor children and your brother-in-law is the guardian, or your mother-in-law is the guardian, things of that nature. Identify those as things you may want to change, globally speaking. Come up with some topic areas that are things that you want to think about. And then go through the documents. So you may not know, for example, what a financial power of attorney is, but see if there is one of those in your current estate planning set of documents. And if there is, pull it out and read through it. You don't have to read every single word of it, but you should take a pretty in-depth look at it, because as you see here, the purpose of that is really somebody is going to step into your shoes in an incapacity situation, or if it's set up where it's more immediate, not even contingent on an incapacity situation, and they're going to have very full and broad access to run your day-to-day, to do things in your life that you would do on the day-to-day, like pay your bills or call a credit card company, or access your bank accounts, access beneficiary designations, all of those various things that could be altered very easily, that you could see certain issues come up. So realize that this document in particular is extremely broad. It is very comprehensive, and it's giving somebody a lot of authority over your life. And so you need to make sure that the person who's identified in there is someone that you still want to act in that capacity. So understand as you go through it, again, when it's effective, who's serving in what role, and make a list. So as you see here, go through it. What are the powers that are in there? Are there things that you don't want your agent making? Is there a situation where you need to change it comprehensively because it's your ex-spouse that is your agent? So contact your group of advisors, talk to your bank. Does your bank have it on file? Does that need to be changed? And look at all of these lists of things to make sure you're comfortable with it. And then at the end of that, ask yourself, am I comfortable with the person who's currently there, or do I need to change the agent? And if you need to change the agent because, again, it's your ex-spouse, for example, and you're in a jurisdiction where maybe it doesn't automatically terminate that, or you just want to clean it up in general, then you need to take the steps to do that. Then you move on to the advanced medical directive, similar to a power of attorney, but for medical decisions. Again, these are life and death type of situations. And so you need to make sure, am I comfortable with who is in the situation to tell a doctor to stop treatment, or to tell a doctor, no, don't do that surgery, or yes, do that surgery. Those, very important decisions. Does it vest in a person that you want to be making that decision, or do you need to change it? Similarly, you're going to go through and do the same diagnosis. When's it effective? Did I say it's effective immediately, where they can call my agent now and ask questions? Did I say it's effective only upon incapacity? Did I give HIPAA authority to my ex-spouse that's in here? And do I not want them being able to call up our joint doctor that I haven't changed and ask about, any illnesses I have, things of that nature? So consider all of that as you're going through it. Make sure you have that right agent in there going forward. Can be the same person as your power of attorney, can be a different person. And this whole series of events allows you to do what I call a review of systems. It just allows you to take a look through all these documents, make sure you understand them on, the terms that are there, and have the right people, the right backups, and doing the right things. It can be separate and apart from the fact that you're getting divorced, but they're kind of one and the same in terms of reviewing and updating and making sure they say what you want. So you have your kind of living documents with your healthcare agent and your power of attorney for financial decisions, and then you transition more into your post-death. And this process of these initial action items of identifying and diagnosing what you have is not a situation where you're sitting there going, what do I want my end game to be? This isn't where you're sitting there brainstorming, should I have a will? Should I do a trust? You're not there yet. You're identifying what do you have now and what is it that I need to think about consulting on or potentially changing. So as you look at the will, these are situations where you've died. Now what happens? So you're going to look at who's in charge, whether it's an executor for administering the estate, whether it's a trustee for making decisions for beneficiaries, whether it's a guardian for a minor child, who's in charge of these various roles, and consider what they would be doing under the document or what they should be doing under the document. And then you look at the dispositive provisions. Where are my assets going to go? And remember, the will is governing assets that are in your sole name. It's not governing, for example, your retirement account that has a beneficiary designation on it. If that beneficiary designation has an individual, that's going to pass to that individual. So you'll see later, we'll talk about that as well. But look at your dispositive provisions. Is everything in here going to my ex-spouse in one way or another? Am I in a jurisdiction where maybe that terminates automatically? And if so, what now? What happens in my document if that no longer is there? Do I have specific provisions in there for children, or am I charitably inclined? Whatever it is, refresh your memory of where your assets are directed and the appropriate way that you want them to be directed in the document, and see if those two things match. If they do, that's great. Maybe you don't have to drastically update them, but more likely than not, given the process and the legal process of the separation or divorce that you've gone through, there are probably some updates that are needed and things very strongly to be considered. And then we briefly touched on that this difference between wills and trusts, and perhaps again you're diagnosing what your estate plan looks like now. So you're also thinking about, is it a will-based plan? Is it a trust-based plan? And if I have a trust, looking at again who the trustee is, who's in charge, who's making decisions. What does the trust say? Does it say that I govern things together with somebody right now, or I'm in charge by myself? And it could have similar provisions like your will. Where are assets going to go? Who's going to be controlling them? Look at provisions and see if divorce affects what's in there, or what jurisdiction was it created in? Is it a Virginia trust? Was it a Maryland trust? All of those things, as you go through the provisions, are things you should jot down to create your own outline of what the document says. Again, not to have a comprehensive knowledge of every little piece of it, but to, again, take it for what it's worth. The initial action items, diagnosing, what do I have? What do I need to think about? And what questions do I need to ask? So you'll see here different things we talked about, and who's in charge, where the assets are going. And then we started to touch on, the idea of retirement accounts and life insurance. Do they have specific beneficiaries? What are they? Do I remember? Maybe not. Maybe I need to go to that custodian of those assets and ask for the documents that show my beneficiary designation. Maybe I need to ask for a change of beneficiary form so that I can update that. Did I put beneficiaries on my brokerage account or any other accounts that I have? Or some jurisdictions now, most of the jurisdictions around here, you can go to the DMV and put a beneficiary on your vehicle. Maybe you have that you need to update too. So again, it's the time to gather up who all of your advisors are, what all your assets are, the documents governing all of that, and make lists of each and figure out what you need to, again, change. This can be overwhelming. There is no doubt about it. That is why you have a team of advisors, whether it's accountants or attorneys or financial advisors that can help you through this. You're not alone in this process. There is absolutely no time where you need to be alone. There is help out there to go through all of this. And then really fresh in your mind should be, as we're making this list, what did I just enter into or what did I just sign that governs what happens when we're legally divorced or we've just gotten legally divorced? Is there a court order that maps it all out? What is it that we agreed to now in terms of some sort of separation or divorce agreement? Make sure that you understand those terms. Make sure that if you consult somebody, estate planning attorney going forward, that they have a copy of that, because many times it's things like that that can get left out of an estate plan that lead to litigation years down the road for not having maintained a retirement account or not having kept a beneficiary on a life insurance policy, or fill in the blank. But we need to make sure that the estate plan matches up with what you're required to do under the separation and divorce agreement. So make sure that you're being cognizant of what those terms are and refresh your memory on that as you're making this list. And then sit back. You've made all these lists, you've looked at the beneficiaries, you've looked at who's in your life, and ask yourself, what do I want? What's my goal for this whole process? What is my intentions going forward? Is it protection? Is it just making sure that you have a baseline plan to go, to update things and then go forward from here, where you feel like you could update it to the bare minimum of what you need now, and you can then get into more comprehensive planning as the years go on and this divorce is behind you. But important to know, not just a blanket list of the who, what, where, and when, but the why. Why am I doing this? Because if you don't have the why, you're not going to have guidance on where to go. And so that's extremely important. And so I would put it in big bold letters on a piece of paper of what your goals are, because that's always the first question I ask every client. What are your goals? What are you trying to accomplish here? So that's important as you go through this process. So we're going to skip through this. We talked about it again. Identify the who is involved in all of these documents. And again, you may want your former spouse to be involved or you may not, but at least know whether or not they are named in any capacity and what the impact is if you change it or if you don't. When you're going through, now this gets even a little bit more specific as we drill down. So you've made that list of assets, okay? If your retirement account, you have your bank account, you have your house, all of those assets that are listed. Now we need to understand, how are they owned? Are they owned individually? Have they been severed through this process where they were joint and now you own 50% or now you own 75%, or maybe you bought out each other in different assets? Whatever it is, understand whether it's a sole ownership, whether it's joint ownership, whether it's owned in a trust, whether it has a beneficiary designation that lists one person or a charity or multiple people. You have to understand the character of what you're planning for, because you may go and create a new will or a new trust, but if all of your assets have a beneficiary designation or all of your assets are joint with a child of yours, that estate plan that you created may be worth nothing more than the piece of paper that it's on, because it's not going to do anything if you already have a designation that governs where the assets go. And so this is, if not equally important to everything else we've just talked about, perhaps it's even a little bit more important, because again, you need to know where you're going from here, and how the planning is going to impact that. Deadlines. Again, those of us who have a partner, sometimes there's a give and take. Maybe I'm the one that manages doing the documents and doing the taxes, and maybe the other partner is managing the monthly bills and the utilities and things of that nature. As you're coming away from the separation or divorce and you're going out on your own through this, identify what the deadlines are. As you're making all these lists and things of, especially of your contacts, reach out to your accountant. Are you on extension for taxes? Are you, do you have a trust that files, a tax return because it's an irrevocable trust, and maybe you need to understand when it files the taxes and how it files the taxes. Do you have other deadlines that you need to worry about, whether it's deadlines that are in your separation or divorce agreement? You have to do something within 4 years, whatever it may be, for example, or is it just something that, maybe it has to do with your children? You have to take certain action by a year from the date that it was signed and 2 years from the date that it was signed, things of that nature. But calendar these deadlines, make a list of the deadlines. Again, you don't want to set yourself up for failure by missing something. You want to put yourself in the best position possible to succeed, whether that's meeting deadlines, whether that's identifying your whole scope of what your plan is, but set goals, identify the deadlines, set yourself up for success. All right, so then now we have our kind of full scope of everything. We've made a list. We're probably sitting at our kitchen table. We have papers spread out everywhere because Adam told you have to go through your closets, you have to go through your safe, and you have to bring everything out that you haven't looked at in a dozen years. And you spread it all out over your kitchen table. So now we need to, after we've made all of these lists, now's the time where we look at, okay, what don't I know? What do I need to know? Can I call my accountant and ask questions about my taxes that I didn't know before? Why is there this deduction? Where is this income coming from? Do I need different exemptions listed? What don't I know? And that's the time where now you circle back with your team. You've made your list, you've completed the picture, and you're taking this proactive approach. Those who may be watching this that know me, or those with Argent Bridge Advisors that know me, one of my slogans is be proactive and not reactive. This is your chance to get out in front of all of this. So you've done all of the legwork here in this part of what we're talking about. Now follow up with your estate planning attorney, follow up with your accountant, set up these meetings. And now's the time to ask your questions to get the complete picture of what you need to know, and telling them what you don't know and have them fill you in. That's why we have jobs. That's why you rely on us. So, there's a list of things here to consider, whether it's legal updates. Again, I mentioned that we're going into a time in the next couple of years where there's going to be potential tax changes in 2025 going into 2026 that could significantly impact some. Know what those are. Ask if they impact you. Maybe they don't. Maybe you don't have to do anything, but at least you should know. Understand going forward, if you had a mortgage, for example, and you, through the divorce process, either assumed it or it was paid off or whatever it is, know what the considerations are now. Did you take on liability? Did you get rid of liability? But what is it going forward? Can I simplify things? This doesn't all have to be rocket science. If you learn through all of this process that you have 10 bank accounts at 6 different banks, can I consolidate? Can I simplify things? Maybe it can be easier. This doesn't have to be where you're sitting at the kitchen table with papers spread all over the place and checking your email and checking the mail and trying to figure out what everything is. And the number one thing to me is always to voice your concerns. What's keeping you up at night after you've gone through this process to identify everything? Is it that you're worried about a budget? Is it that you're worried about what your power of attorney says and that somebody's going to have too much authority over your life? Whatever it is, make that list of those concerns so that you can bring them to your advisor, to your accountant, or to whoever you're going to have any of these meetings with. Again, I go back to create that outline, create an agenda, list the goals, big bold letters. What is your goal to accomplish? And it can be in any topic area, financial, legal, tax. Do you have a parenting plan that you want to accomplish? Is it time for college? Is it time for planning for grandchildren? What are you trying to accomplish moving forward? Again, same list. Keep this front of mind as you're going through this. Voice the concerns. So if I'm going to voice them, I need to write them down. What are they? Is it that I want to set up a gifting plan where I'm putting money in a 529 plan for my grandchildren and making sure I do that on an annual basis? Is it that I'm going to start a new business? Is it that I'm going back to work? And if I'm going back to work, am I going to be self-employed? Maybe I need to create a certain business entity. How do I do that? What's the impact to me? There's so many tentacles to all of these things. None of us can remember them in our heads. If you look at my desk, I have lots of sticky notes that are sitting here. I have pads of paper on both sides of my keyboard. I'm constantly writing things down because there are too many moving pieces in everybody's lives right now to just remember it in our heads. Unless you're like my wife who has a photographic memory, then you can remember things. But most of us need to write these lists down. And so I think it's important to look at a slideshow like this and certainly keep remembering that there are outlines, there are lists, there are agendas. When you go into any of these meetings with an accountant or with your tax advisor, financial advisor, attorney, bring an agenda in there. That's great. You can tangibly hand that to who you're meeting with and say, these are the 6 things I want to make sure we cover before I walk out that door. That sets the tone. That lets the advisor who you're meeting with know a lot about you, including that you're serious about this and you're invested in the process. That is more meaningful than you can ever imagine for those of us who are having these meetings. But make sure that you list them down. There's things that you might not even think about that you put on your list, you set it aside, you come back to it the next day and you remember, oh, do I want to change my name back? Did I change it previously? And if I do want to change it back, what's that process like? And what does it impact? Does it impact just my driver's license? Does it impact my benefits? Does it impact, taxes? What does it impact? All the questions and things like that. Sometimes they're little, sometimes they're big, but write them down. And so as you're writing all these things down and waking up at 2 o'clock in the morning and saying, I can't believe Adam put all these things in my head because now I can't sleep at night. You've got to identify those who can help you. As I mentioned, you don't need to and shouldn't take this on yourself. And so when you're identifying those who can help you, it's interesting nowadays because so many of us meet just like this, that it seems so easy that I could meet anybody by Zoom. But remember one of the first things we talked about, where are you? Are you in Virginia? Are you in Maryland? Are you in DC? Make sure who you're meeting with and who maybe you got a referral, make sure they can actually address what you need. If you go and you live in Virginia, but you're only going to a lawyer who's barred in Maryland and DC, that's not going to help you as much. So make sure that before you go in, do your research, do your due diligence on who you're meeting with, so you can make sure, where am I? What's my domicile? And again, do I plan to move? Is this a temporary kind of band-aid where I need a plan that will get me through the next year in Virginia, and then maybe I'm going to relocate to Florida? And if I meet with Adam and he can help me in Virginia, does my plan transition to Florida? And if it does, can he also help me when I'm in Florida? Those are the kinds of state-specific and specific questions in general that you want to be asking. And you do want to ask because this is an expensive process often. You want to ask, if I go through this process and I spend the money, if I relocate, does that change everything? And do I have to go through the whole thing all over again? It's important to know. But the one thing that you have to make sure is that you don't delay yourself of getting in the office. You can't let little things like not necessarily being able to figure out who my backup fiduciary is, or little pieces of this puzzle. Don't let it paralyze you to the point where you don't get in to meet with your advisor. If you don't remember anything from the rest of the presentation, remember that. So many times, one of the biggest things we see is people get paralyzed over one small puzzle piece, and they don't start the conversation, and it then becomes a situation where the conversation is not started until it's too late. Please don't let that happen to you, especially after you've gone through such an event like a separation or divorce. Have the conversation. If there's missing puzzle pieces, you will sit down and figure it out with your advisor, but at least have the initial conversation. So many of us, myself included, often when it comes to my personal planning, I don't do something unless I have a deadline sometimes. And so set up a meeting, put it on your calendar, make it for Friday. If I don't do this by Friday, then, or if I put it on the calendar for Friday, I'm going to be prepared by Thursday night. It's going to force me to do it. And so many of us who I know, I have a sports background. You can't tell from my golf stuff behind me. If I operate out of fear that I'm going to embarrass myself in a meeting, I'm going to prepare for that meeting. Or for me, I look at it, if I have court tomorrow, I'm going to absolutely be prepared out of fear of every single possible thing that could happen. So set up that meeting and be prepared for it. And, if you don't set the meeting, it's just going to linger. So as you're making these lists and you identify, your advisors, send an email, call them up, put the meetings on the calendar. If they're going to be all virtual, maybe take a day off of work and do 2 or 3 of them in the day. Meeting with your financial advisor, your accountant, and your lawyer in the same day, they're all going to overlap a lot, and you might get a lot of your questions answered. So come up with a plan to do that, but at least set the meeting so that you're accountable to yourself. And all of these things that you've outlined, your asset inventory and your beneficiary designations and your goals, bring it with you. If it's an outline that you made that perhaps isn't as coherent, make sure that you list it so that it's more coherent as you go in. Type it up if you can't read it, things of that nature, but bring it with you so that you remember what questions to ask. So what happens if I don't do this? So we've talked about, I'm going to put all this work in to identify it all. We're going to figure out what we have. We're going to figure out what we need to change. And we're going to identify those people that we need to go to do it. And we're going to set up that meeting to get there. And that process, again, sounds easy, but it's going to take some time. Emotionally, physically, there's a lot that's going on that you're going to deal with. But as you get to that meeting and you make the meeting, now you've gone and you've gotten informed. And okay, this is the steps I need to take. Well, what happens if I don't do that? What happens if I decide, you know what, I can't handle it? Which many of us, we get to that point on a daily basis. So what happens? Well, if we don't have a plan in place, now we're uncertain what's going to happen. What's going to happen to me if I need a guardian? What's going to happen to me if I'm incapacitated? What's going to happen if I don't have a beneficiary on my retirement account? So you have a lot of uncertainty. And when you have that uncertainty, you drop down here and you look at, from an estate planning standpoint, we default to the rules of the jurisdiction where we are. So I would have to look to, what does the estate and trust code in the jurisdiction where I am say about if I don't have a will? It's called intestate, or intestacy. If I don't have a trust, if I don't have a beneficiary designation at my retirement account, what do their rules say about where it goes? And I will tell you, recently, I have actually had litigation where companies have changed, and one says it goes one way when you don't have a designation, and the new company says it goes a different way. And if you don't spell it out and take control of it yourself and do things and put them in writing when you have the opportunity to do it, there is a high likelihood that things are going to occur that you didn't want or didn't intend. And so that's the goal, is to avoid that by mapping all of this out. So again, one of the biggest consequences is uncertainty. Another consequence there is the potential for unintended benefits to anybody, let alone your ex-spouse. Again, there's some jurisdictions like Virginia and some places where in some assets, it automatically terminates when you get a divorce. But there's other jurisdictions where it doesn't automatically terminate. And so what does that mean? That means that, we've all seen it where there's a life insurance policy that has an ex-spouse listed and it never gets changed. And at the end of the day, the ex-spouse has a falling out with the kids and the ex-spouse gets $1 million life insurance policy. And everybody's left extremely upset at the end of the day. Don't let that happen to you. Be informed about it. What else? What other consequences? We talked about meeting deadlines and familiarizing yourself and sticking to what's in that separation and divorce agreement. Understand, there's consequences if you don't comply, whether that's being in contempt and having to go back to court, whether that's potentially having claims against your estate at the end of the day in litigation. There could be things where if you don't meet a deadline, it may negatively impact you on how the agreement plays out, whether it's payments made to you or decreased or things of that nature. So there can be severe consequences if we don't take action or if we don't pay attention to what we need to. And again, liability can come in all shapes and sizes. It doesn't have to be one thing, but if we don't take action to update ourselves, inform ourselves, and kind of move forward, we could be held liable for certain things that are lingering. Where you are in this process, these are two of the biggest things that we're all seeking. We all seek this on a daily basis anyway, but when you go through a big event, a death, a divorce, separation, things like that, what you want is closure, close the door, move forward to the next, portion of life or to the next happy event, hopefully. And so by keeping motivated and by addressing these things, you're going to get closure. Again, it doesn't have to be rocket science all the time. It can just be identifying it, making lists and having those meetings, and then being able to walk away going, okay, I'm informed, I've got my team. I feel that I can close that door and not have things lingering, and now I can move forward and build a positive future. And that's, by taking action, that's what you get. These two big things, closure and peace of mind. If we don't do that, then there's anxiety, and anxiety is, always difficult to deal with. It has its own tentacles. So take the action, gain closure, and be able to rely on your team going forward. And then, finally, as you've set these things up, what happens going forward? Again, you see my statement there that I stick to and I live by: be proactive, not reactive. Get ahead of it. You don't want to be reacting at the end of the day, where somebody's ill, you're ill, you have a situation, and you're scrambling to try to get things done when it's not an appropriate time or you're not in the right frame of mind. So get out in front of it, be proactive, do all of these things when you can. Be timely about it. Again, the closer you are to the triggering event of why you're looking at this, the more motivated you can be to get it done. The farther you get away from that event, the less likely you are to address it. And so be timely, be specific, be intentional about what you're trying to accomplish here. Again, don't linger, have the meetings, get the documents prepared, get the beneficiaries updated. Don't let them sit around, on your kitchen table, and 2 years from now, they're still there and you haven't addressed them. Get it done quickly so that you can move on. And the one rule that I always have for clients of people that I will work with in particular is the rule that you see there in the middle of the page: invest in the process. Be present when you go to these meetings. Don't just go through the motions. If you're just going through the motions, it's not going to do you any good. So invest in the process. When you go meet with your accountant, when you go meet with your lawyer, and you come in with your list and your agenda, be present. When they answer your questions, make sure you understand it. Make sure you ask follow-up, take notes, so that you can then go forward, and when you sign that will in the future, you know what's in there and you can be comfortable with what's in there. So implement what you're trying to accomplish. When I said put big bold letters what your goals are, and then review them over time. Every year you should dust off your documents that are in your house, and just take a flip through. Make sure people that are in there are still people you have a relationship with and you're still comfortable with being in the position that you put them. The more minor things, every few years, 2 to 3, take a more comprehensive look. Maybe in terms of your kids getting older, should they take on more responsibility? Maybe you don't have to restrict things as much, or maybe you've moved and everybody has different addresses and there's different rules where you live now. Maybe you've acquired significant assets in the time frame. All of those various things could dictate you calling your attorney and saying we need an update. And make sure if you are going to have a situation where you stay somewhere temporarily right now and you're going to just try to get things done so that you kind of bring up the status quo and can be comfortable with it for the short term. If you move, please ask for 2 things. 1, how does this impact my plan? And 2, can you please refer me to somebody where I'm moving so that I can go consult with them to talk about the local rules. And with that, we'll conclude. I'm always happy. Those of you that have my information here, please reach out. You can email me, call me. I am always happy to answer questions, talk through any of this stuff.
Great. Really appreciate all the information, Adam. And I just want to, again, just reiterate what Adam said. It's really important just because when you're married, you're going to have a lot of that transfer from spouse to spouse, and it's very different when you're planning just for yourself. So definitely important to take care of all of these things. Thank you.